We are now welcoming panel 6, which will address the issue of monitoring for the purpose of protecting human rights. And Article 7.2 of the proposal for a screening regulation foresees that each member state establishes an independent monitoring mechanism to ensure compliance with fundamental rights. However, the establishment of such mechanism will help protect fundamental rights only if the mechanism is really, truly independent, both in law and in practice, and provided it has adequate financial and human resources and financial and operational autonomy. And additionally, national monitoring mechanisms will be able to fulfill their role provided they have the power to conduct not only announced visits, but also, and even more importantly, I would say, unannounced visits, and provided they have access to documents, to places, to all individuals that they want to talk to, and provided they can publish reports, they can give recommendations, and they can make referrals to the national persecution authorities. So it is really questionable whether member states will be willing to fulfill these requirements and what will be the relation between these mechanisms and national human rights institutions, particularly the national ombudspersons, as well as what will be the relationship between these mechanisms and the fundamental rights officer. And the establishment of, as far as I know, the first such monitoring mechanism by a member state in Croatia might serve as a useful pilot, and maybe, hopefully, I would say, as an example of good practice. Time will show. In any case, member states might look at it as a pilot of good and bad things in case they have to do the same, of course, provided the screening regulation ever gets adopted. So these are just some of the issues that I expect will be addressed in this panel by the experts Philip has managed to gather here. And each speaker will have 10 minutes, followed by a short discussion, because we only have 1 hour for this session. So I will be rather strict with the time. And there is a slight change in the order of speakers, because Dr. Jonas Grimheden, the Fundamental Rights Officer, might have to leave before the end of the session. So I was asked by Philip that we put him as the first speaker to address the topic of the scope of the mandate of the Fundamental Rights Officer. So, good morning, Dr. Grimheden. Can you hear us and see us? And welcome.
Thanks, Iris. Thank you very much.
So the floor is yours.
Thank you so much. Pleasure to be with you here this morning. Sorry for squeezing myself into the beginning of this panel, but I'm grateful for this flexibility. I want to explain maybe two things. I want to explain the nature of the office that I have the pleasure to hold since 3 months, and also explain the tools that I have at my disposal. Firstly, then, on the independence, this is the first, I'm the first person to hold this post. It, as you are probably well aware, it's a post that is initiated with the 2019 regulation, and I am then the first recruited person to hold this. There has been an interim person, but I started 1st of June, coming from the Fundamental Rights Agency in Vienna, where I worked for many years, so I have a solid fundamental rights, human rights background. And I think that was also part of why I got the post. I was an external recruitee, and bringing in knowledge on the substance, and had a good track record of delivering independent advice at the Fundamental Rights Agency in Vienna for many years. Before that, I come from academia and capacity building, so I have some insight that I bring from that perspective too, working a lot on monitoring mechanisms, independence of the judiciary, etc. And the independence with this new regulation is particular for me. So the agency and the European Union has made a lot of effort to accommodate, to ensure that I'm independent. So apart from being recruited externally, I also was recruited by the management board, so not by the executive director. I don't report to the executive director, I report to the management board of Frontex. And that goes for every little detail. From signing contracts with the staff that I have, down to that the management board looks at my time schedule and sees if I have worked until through the core hours or whatever. I'm not sure they look at that in detail, but formally that's the way. So in all aspects, I feel and legally I'm independent under the management board. So fully advising independently the management board and the executive director and the business entities here in Warsaw. So that's, I could say more about independence, but maybe enough to simply flag this. And my experience so far in the first 3 months is that the organization is also delivering on this, very careful about my role, great awareness about independence and understanding for that particular role. Coming then to the tools. So depending on when I talk about this, I have a different number, but I think I could say I have 7 tools at my disposal. So first and foremost, a complaints mechanism that is in my control, in my hands, where we are able to receive complaints by persons that feel that they have been affected in a fundamental rights related way by activities in Frontex operations. We unfortunately have very few complaints. I'm not pleased with that, but it's a good mechanism that I hope we can make better use of in the future. Second tool is serious incident reports, where there's an obligation for all persons participating in Frontex operations or Frontex joint operations to report serious incidents. And that could be ordinary activities, accidents, etc. But as soon as they relate to fundamental rights, the fundamental rights officer is in the lead to investigate, if you will, to follow up on these incidents. So then the business entity that deals with that here in Warsaw hands over that to me. If there's a unclarity if a case relates to fundamental rights or not, we are consulted and can weigh in and say this is clearly a fundamental rights issue, we take over, and then we are in the lead. This is a tool that is increasingly used. Awareness is increasing in the organization and the usage is increasing. I fear also because of problems that we see in the field. Third tool is monitors. According to the regulation, we should have had 40 fundamental rights monitors by 5 December 2020. We now have 10th of September 2021, and we have 20 recruited and in office. So we should have had 20 more, but I hope we at least can get close to 30 this year, and before summer next year, I hope we could reach the 40. The 20 that we currently have been deployed already. Some of them I joined them on some missions. We've been to Spain, Greece. We have plans for and Lithuania. We have plans for Hungary and Bulgaria in the coming weeks, and another trip to Greece. And we have other countries and operations in mind. These 20 have undergone a solid training. I was with 10 of them this week in Amsterdam, and the other 10 for an intensive week in Italy next week. And they also come with a very impressive, diverse but very impressive, solid knowledge of fundamental rights, of experience of monitoring, all externally recruited with a very, very strong independence guarantee also in the regulation. So again, employed directly by me, not by the executive director, and are independent in their role, different from the rest of the organization. The fourth tool is Article 46. According to the regulation, the fundamental rights officer has the possibility, a right to advise the executive director to pull out, restrict, not initiate operations or elements of operations. And in practice, that also then gives us some leverage by saying we think you should pull out unless A, B, and C happens. And that is a tool that we are exploring more and more, and I think that can be a very useful tool. Pulling out is not necessarily, as I've said in other contexts, is not necessarily the best solution, but I think the leverage that comes with that could be very, very useful. Fifthly, advice on all the business entities, processes, strategic plans, operational plans, continuation of rapid border interventions or not. In all these processes at Frontex, we are involved by procedural guidelines. So the last 2 years, we've been involved in about 50 per year of these types of processes. Could be smaller, but sometimes also more significant things, like providing input on operational plans. And what I've seen so far is that the advice that we provide is taken on board. So we are saying this should be in the operational plan, and then it ends up in the operational plan. Or this should be in the evaluation of the return operations, and then it ends up there. Or this should be in the working arrangement with third countries, or in their codes of conduct, and we improve those documents as well. So altogether, 51 per week about that we comment on various, again, more serious or more significant types of processes or lesser. So that was my fifth. The sixth tool is a sort of separate entity, but the secretariat for that is within my office, the Consultative Forum, bringing together a number of international intergovernmental organizations and civil society organizations, including the Fundamental Rights Agency, where Tamas, who will speak later, is from, but also UNHCR and other key actors in this field that do their own assessment, monitoring of the work of the agency, but also, of course, interacts significantly with the independent office that I lead. The seventh and last tool, and that will bring me, I think, to the 10th minute, is return monitoring. So a specific element of monitoring where we, again, by the regulation, I have the possibility to appoint forced return monitors from the pool of fundamental rights monitors. The regulation doesn't specify, but the management board decision says that there should be 5, so 5 of the eventually 40, and I've appointed already, I think, 4 monitors that have been trained and appointed, and that are already been to several return monitoring missions and monitor the return flights. And we do that in a strategic way. Sometimes we fill gaps when there's a need to fill these gaps, but more importantly, we try to be on the return flights where we see that there could be problems, where we have concerns, etc. And I think this is also a tool in the toolbox that is not sufficiently tapped, that we could do more with, be more strategic, more systematic, etc. So thank you very much for listening to me the last 10 minutes. In short recap, I talked about my independence. I talked about the 7 tools that we have, complaints, serious incident reports, the 40 monitors, Article 46 to the ED, advice on business entities, the Consultative Forum, and returns monitoring. Thank you very much.
Thank you so much, Jonas, for explaining what the Fundamental Rights Officer is supposed and entitled to do, and how this is actually done by explaining the tools that you have before you. So I hope that you can stay a little bit maybe for the discussion, and maybe we should invite the audience later to direct the first questions to you if you have to leave early. Our next speaker will be Ms. Eva Tzavala, who will also be online. She is the chair of the Asylum and Immigration Working Group of the European Network of National Human Rights Institutions, and she will address the issue of which independent monitoring mechanism of refoulement. So, Ms. Tzavala, please go ahead.
Good morning. Thank you, Ms. President, and thank you also to the Asylum Network and Professor De Brucker for the invitation. As you clarified before, our panel addresses, with a critical eye, of course, like the rest of the conference, the particular subtopic of the monitoring for human rights violations, and especially at borders. And my contribution will focus only on one article of the Pact, Article 7, of the screening regulation, which has already drawn a lot of attention, coming as a response from the European Commission to repeated calls by international organizations, national human rights institutions like us, civil society, asking for more accountability for human rights violations at borders. Next slide, please. ENNHRI, which I represent today, is a network of 47 national human rights institutions across Europe. We have members not coming only from EU states, but also from Council of Europe member states, and this has an added value when we are talking about migration management. ENNHRI provides a platform for collaboration and solidarity in addressing human rights challenges, and it's a common voice of NHRS at the European level, like today. Its main mission is to strengthen, support, and connect European NHRIs. And why I'm here? Next slide, please. ENNHRI has issued an opinion on independent human rights monitoring mechanisms at borders under the EU Pact on Migration and Asylum. The full text of the opinion is easily accessible on our site. And during my presentation, I will go through the main points: how we, NHRIs, perceive the Commission's proposal and what we particularly recommend to EU legislative organs and member states based on our experience as state-mandated bodies, independent from government and with a broad mandate to protect and promote human rights. Monitoring compliance of state authorities with international, regional, and national standards monitoring is part of our everyday job work. Especially with regard to monitoring migrants' rights at borders, ENNHRI had successfully run a 2-year project which ended this summer, and we have presented the preliminary findings during a high-level event, and the final report of the project will soon be out. In this context, and even before the launching by the Commission of the Pact, ENNHRI has stressed that there is no need to create new monitoring mechanisms, which was our former position, rather strengthen existing ones. And why? Because alongside other human rights defenders, we are also human rights defenders, NHRIs are playing a crucial role in independently monitoring Europe's borders, and their work should be reinforced. They provide credible and comprehensive reporting on human rights violations. We help authorities to make informed decisions about their border governments, and we shed light also to systematic problems that need to be further addressed, tackled, or prevented. Next slide, please. Our prominent role in preventing pushbacks at borders has been acknowledged by the Council of Europe, the Community of Ministers in particular. And at the EU level, what is important is that the European Parliament acknowledged the role of NHRIs in monitoring human rights in forced return of migrants, and recommended that NHRIs should be part of these new monitoring mechanisms to be established at borders. Member states, as we know from the screening regulation, member states may invite them, I quote, the specific phrase is that they may invite relevant national, international, or non-governmental organizations and bodies to participate in the monitoring. So what we understand is that at discretion of each state, I think yesterday also during the panel from screening, there was this impression that it's up to the members to decide on the composition of this new mechanism. And of course, our position is that NHRI should be consulted by the state authorities prior to the establishment of these monitoring mechanisms, not just NHRIs, of course, I'm representing NHRIs here, but other relevant actors and national preventing mechanisms, civil society organizations with monitoring experience, not just us. But we at ENNHRI level, we encourage our members and HRIs to get involved at national level in the deliberations. Next slide, please. Okay, the ENNHRI's opinion on the specific matter of monitoring mechanisms addresses their 10 recommendations, as we said, to EU organs and member states. This is the list. For ease of reference, and I don't have much time, I have grouped in 3 bigger categories: independence, scope, and accountability. Next slide. Independence. Securing the independence of these monitoring mechanisms is a precondition for their effectiveness and credibility. It does not suffice to say that member states have the obligation to place adequate safeguards to guarantee the mechanism's independence. This is the phrasing of the text. What kind of safeguards? There must be specific criteria. One may draw also inspiration from the human Paris principles that govern the operation of NHRIs. And in addition, these criteria should be regularly assessed by the European Commission in cooperation with other bodies. And it's of course positive that the Fundamental Rights Agency has a particular role in the establishment of these monitoring mechanisms by providing guidance to member states. Mr. Molnar will analyze further this issue. And important aspects for the independent, strong and effective mechanism is the other element is adequate resources. Iris mentioned, I think in the beginning, that We need sufficient funding, not only state funding, but EU funding, qualified personnel, and of course, an adequate number of personnel. One important element is to be able to decide freely on the allocation of resources, and FRA also can play a role in capacity building regarding personnel. And finally, drawing from the experience of ENNHRIs, states must secure an enabling space, that was the last point, for an effective and independent functioning. The mechanisms should not face threats, intimidation, or reprisals from public authorities. It's a sensitive matter. We have the previous ENNHRI experience of people facing threats, and personnel must be protected from any legal charges. Next slide, please. The scope of the mechanisms. Okay, the title of my presentation today is which independent monitoring mechanism of refoulement. This monitoring mechanism, as sketched by the EU Commission, is surely not a monitoring mechanism where all kinds of actions likely to infringe the principle of non-refoulement will be detected. First of all, the text itself limits the competence of these mechanisms, ratione materia and ratione loci, during the screening. Once third country nationals have reached official structures and are undergoing identification, registration, debriefing, and fingerprinting procedures. And indeed, of course, violations, fundamental rights violations and violations of the principle of non-refoulement may occur at that time. However, blind spots remain in between crossing the borders and reaching the authorities. In the explanatory memorandum, the scope of the non-refoulement principle is linked with Sagink's Code, Article 3b. Therefore, it's safe to conclude that this monitoring mechanism will be also present at border crossing points, checking on compliance with the principle for non-refoulement and the right of access to asylum provided by the Charter of Fundamental Rights. ENNHRI recommends the expansion of the scope of the monitoring mechanisms to actions and inactions in the wider context of border governance outside official procedures, border crossing, and facilities. The text explicitly provides also that these new mechanisms have competence to monitor detention places, to ensure compliance with national rules. Two remarks. First, it goes without saying that the detention measure will be assessed based also on international and regional standards and not just national law. Second remark, ENNHRIs often are designated as NPMs, so their interrelation between NPM's mandate and the new monitoring mechanism should be clarified from the beginning. In general, one of ENNHRI's main concern is that ENNHRI's mandate should be respected when establishing and implementing the monitoring mechanisms. These new mechanisms do not come in a vacuum. Different bodies already exist and do exercise their monitoring competence on migrants' rights. Coordination among these different actors shall be ensured, and of course, respect for each other's mandate. In order to succeed in their monitoring mission, these mechanisms provided by the screening regulation must be seen as part of the wider human rights accountability system at national, regional, and international level even. Cooperation, coordination, coherence, complementarity, interrelations, these are the keywords, must be our primary considerations when talking about creating a new mechanism that will add in an already complex and dysfunctional monitoring system. And the last point on accountability, next slide. As mentioned in multiple occasions, as we know, monitoring is not an end in itself. Monitoring should lead to better protection and human rights accountability. This is, of course, linked to what I have just explained about the wider accountability system, but also this mechanism should be vested with adequate and strong powers. Also, the President talked about it. The proposal itself is silent on the matter. The mechanism should be capable to ensure access for justice, refer information, as you said correctly, public recommendations, etc. Have unhindered access to places, unannounced visits, etc. And based on our own ENNHRI's experience, an obligation of national authorities to cooperate, this is also important to have an obligation, specific obligation to cooperate and respect the mandate. And we need a follow-up procedure of the recommendations and consequences when the states do not comply with the mechanism's recommendations. And on the other hand, the accountability of the mechanisms itself should be ensured. Inner accountability, let's say, information about its compositions, the powers, the actions must be publicly available and easily accessible to allow for public scrutiny. This will add, of course, to the transparency and credibility of the whole system. ENNHRI notes with satisfaction and great interest also that other relevant stakeholders formulated reasoned opinions on the independent monitoring mechanisms, such as the UN, the Office of the High Commission of Human Rights, the UNHCR, NGOs, CPT, also the European Committee for the Prevention of Torture. And there is a research commissioned by the EU Parliament and published last July, provides useful insights on how this monitoring mechanism is perceived. And also Odysseus Network has been published, Monsieur Lanoin blog article about the independent monitoring mechanisms in the bigger context, in the right context, has placed these new mechanisms. And I'm eager to hear comments from Mr. Tamas and other participants in distinguished colleagues that I see in the audience. Thank you very much.
Thank you so much, Eva. Thank you for explaining the work of ENNHRI and the principles which are the basis of its work. And if I understood you correctly, what you are actually saying is that what the screening regulation or the proposal for the screening regulation does is actually add another mechanism which overlaps with what we already have with the national human rights institutions, which are entitled, based on their mandates, to do the monitoring. So the question is, when we have such an overlap, in case the screening regulation gets adopted, what does that mean? Should the national human rights institutions be part of the national monitoring mechanisms which are intended to be established by the screening regulation, or would that mean overstepping over your mandate? So that's one of the questions that we can discuss in the discussion part. Thank you. So we are now moving to our third speaker, and that's already that's Tamas Molnar from the EU Fundamental Rights Agency. Good morning, Tamas. We already heard you speak yesterday, and it's a pleasure to welcome you again today. So please go ahead.
Thanks a lot. Good morning. Thanks, Madam Chair, dear Iris, for giving me the floor and the kind words. Distinguished speakers, dear participants, dear colleagues, it's my great honor and privilege to be here with you. Again, thanks go to the organizers as well, to share with you some thoughts and observations around the planned or proposed independent border monitoring mechanism under the screening regulation, also reflecting on what the previous speaker, Eva, has expressed from the perspective of national human rights institutions. To start with, by zooming out a bit, effective and independent monitoring protects people with whose fundamental rights might be at risk, of course, but it also protects the state and its institutions by providing unbiased and neutral reporting, thus strengthening its accountability and enhancing public trust. And essentially, monitoring fundamental rights compliance is particularly beneficial for actions, state actions, which occur in locations where the public has no or very limited access. To give another example, to draw a parallel, the forced return monitoring system set up under the Return Directive, which has also been mentioned by Jonas, the Fundamental Rights Officer of Frontex, but also by Eva. So the forced return monitoring systems illustrate the added value of the independent and effective monitoring of immigration law enforcement activities. Now, zooming in on the external borders, EU external borders, as border control is bolstered to address a highly challenging environment, mechanisms to monitor adherence to fundamental rights should be equally enhanced. We know how much money and infrastructure is spent on the border industry. To counterbalance a bit this situation, border monitoring needs to be stepped up in its various dimensions. And the monitoring should result and should lead to recommendations, of course, which help identify and correct possible shortcomings. And it should also support victims to access their fundamental rights, access to justice, and a legal remedy. And put it more broadly, monitoring is not l'art pour l'art. It must be followed up by effective investigations to go with the full circle to make sure that the findings of the monitoring activities are then sufficiently picked up and there's a concrete action on the basis of those. Then having a bit of a historical retrospect, there's nothing new under the sun. There's nothing new. The idea of border monitoring is not new. Just think of UNHCR's traditional efforts, especially in the beginning of the years 2000, when the UN Refugee Agency promoted border monitoring in Central European countries and established tripartite agreements between UNHCR, local border guards, and NGOs to monitor border control along European land borders, especially in light of the then prospective EU accession of these countries. Think of Hungary, Slovakia, Romania, Poland, Slovenia, Bulgaria, Croatia. Now there's a new one, but historically this is not the first time there's border monitoring. For some dinosaurs in the field, notions like the Uzhgorod process or the Trakai Forum might sound familiar. The Uzhgorod process was a joint pilot border monitoring project between Hungary, Ukraine, and Slovakia in 2005. Or the Trakai Forum that was convened by NGOs as the first regional forum on border monitoring in 2004 in Lithuania, which then established the code of conduct for border monitoring. And against this backdrop, now I would like to speak a bit about the proposed mechanism in the screening proposal. Article 7, it has been already mentioned. I will not dwell upon what is written, what is proposed. There's a role foreseen for FRA, for sure. The Fundamental Rights Agency is meant to issue general guidance for member states on the setting up of such a mechanism and its independent functioning. And in addition to that, which is an obligation, it's a shall clause, member states may request the agency to support them in developing their own national monitoring mechanism, including the safeguards for independence of such mechanisms, as well as the monitoring methodology and appropriate training schemes. In addition, I should mention that according to Article 7, member states may also invite relevant national and international bodies and NGOs to participate in the monitoring. So this is FRA's role with this added layer of the possible involvement of other actors. And in general, of course, FRA is supportive of this proposal. We welcome that it's out there. We are supportive of monitoring to be carried out by national actors. Definitely, this allows adjustments to the realities on the ground and can build on the work of national human rights institutions and national preventive mechanisms. So in this regard, we fully subscribe to what Eva has said. There's a clear statement of independence in the proposal, and independent national monitoring mechanisms have clear advantages. Monitoring can help identify problems, gaps, training needs. It could increase transparency on the fundamental rights situation at the border, and it can help address deficiencies and facilitate investigations. So here again, it's important to link it to facilitations to go the full circle. The proposal also sets out the duty to investigate allegations into fundamental rights violations. All good. However, there are some concerns. The first is related to the material scope of the mechanism. Since with pushbacks being one of the key fundamental rights issues at borders, the highest need for monitoring concerns border surveillance activities, not at BCPs, not during the screening per se, but along the green borders, out in the woods, in the mountains. And this is not covered in the text so far, so it should be made clear that border surveillance activities where those pushback and refoulement incidents occur are also covered. Then detention is under the purview of monitoring, but the procedural safeguards and detention conditions should also be mentioned explicitly, since the text is now silent on that, which could be also accompanied by the member states' obligation to comply with the international standards. Then the independent safeguards could be spelled out in the regulation itself. Then we think that a non-affection clause might be helpful, meaning that the regulation could clarify that it does not affect mandates of existing monitoring bodies. It also echoes what ENNHRI has just said. And the investigations, the current language of the investigations meaning that they might be effective and carried out in an appropriate way, should be, how to say, beefed up to meet the standards of the European Court of Human Rights, according to the case law of the Strasbourg Court, investigations must be prompt, expeditious, and capable of leading to the identification and punishment of those responsible. So the ECHR requirements are more stringent than in the proposal. Then, as for the future, the Fundamental Rights Agency, of course, stands ready to contribute with its expertise in this way, in line with the provisions which will be set out in EU law. It's still a moving target. Whatever will be adopted, of course, we will do our utmost to deliver. It's important to highlight that the proposed rules will not give FRA a monitoring mandate, but the agency needs to undertake capacity building work to help member states set up their own systems. Not mentioning that FRA doesn't have the capacity to do monitoring itself on the ground either. Then several preconditions and prerequisites have been mentioned around the effectiveness, around the independence and its various dimensions, also on the complementarity of the mechanism. So I will not repeat those elements, but we also subscribe to those. So they are essential components of an independent and effective border monitoring mechanism. During the ongoing negotiations, the technical details regarding the relationship between FRA's role and the national monitoring mechanisms still need to be defined. And once the mechanism or the screening proposal and the provisions on this monitoring mechanism will be approved, the Fundamental Rights Agency will engage with the Council of Europe, where the CPT is a key player in this domain, and the Subcommittee on the Prevention of Torture, as well as with NPMs to conceptualize the mechanism, and also during its establishment when developing the guidance and methodologies and designing training. So we are fully committed to explore the synergies and to work hand in hand with other established actors in the field of border monitoring. So I would leave it here. I'm happy to take questions. I'm at your disposal for the ensuing Q&A session. Thanks a lot for your kind attention.
Thank you so much, Tamas. Thank you for explaining and spelling out the FRA's supportive role to the future monitoring mechanisms. And thank you so much for emphasizing that actually the monitoring mechanisms, the scope of the monitoring should be extended, should be expanded. That basically it would be much more useful to expand monitoring to what comes before the screening, in order to actually prevent or reduce pushbacks. And what I would add is maybe also to expand monitoring, not just to screening, but also to border procedures. So that's something that we could explore in the discussion. Thank you. Our next speaker is Mr. Omer Shatz, the director of Front-Lex, who will talk about the pleas in the action for failure to act against Frontex before the Court of Justice. This is a very interesting topic. Since we are all lawyers here, we are mostly interested in the legal aspects, so we would really appreciate if you could explain the background and concentrate on the legal points. Please go ahead.
Yeah, thank you very much for the invitation, and I suspect that the interest lies in the legal part, less so in the factual part. So I'll really briefly, just concisely, will describe the facts. The facts are what we are dealing with is about 10,000 civilians asylees that are kidnapped either from EU land or EU soil, either from EU soil or EU waters by EU agents. Then they are forcibly transferred to unworthy vessels, and then they are abandoned and see 10,000 civilians, among them 2 of our clients in this case. I think we've all seen the videos, and I don't think there is an evidentiary issue here. The German Federal Minister of Interior received from Frontex the confirmation of 132 incidents where Frontex was involved. The UNHCR reported to Frontex on hundreds of documented events. And really, I think we can skip the factual, the evidentiary discussion. Even Monsieur Leggeri himself reported eventually to the parliament that he is watching in Warsaw with his colleagues how collective expulsions, one of the worst serious breaches of human rights violation, unfolds on the screen. And also the Greek government saying that everything that they are doing is the implementation and pursuant to a Frontex policy, that Frontex is on the ground with them. So we can skip that. Just I will say one thing about the involvement of Frontex, how Frontex is implicated in this joint operation, Poseidon and previously the Rabbit border intervention, Aegean. So Frontex is involved directly because Frontex also tasked with the surveillance, with the detection, with the interception, and the handing over of the situation of the asylees to the Hellenic Coast Guard. So they are actively and directly complicit and involved. But they are also indirectly, of course, they are the one who finance the operation, they are the one who draft the operational plan, they are the one that coordinates the operation, and they can stop, initiate, and do whatever they want with this joint operation. Then we come to the law, and the law is quite simple, contrary to the complexities that many lawyers in Frontex, also the new fundamental rights officer, try to create this impression. Our case, legally speaking, says that Frontex fails to act within the meaning of Article 265 TFEU in infringement of the treaties. Which treaties? The Charter of Lisbon, first and foremost, the right to life, the right to seek asylum, the right not to be refoulement, and the prohibition, of course, on collective expulsion. Abandonment at sea creates a risk to life. A risk to life can amount to attempted murder. The best friend of one of the two clients, or in our case, drowned to death during one of the attempts to seek asylum in the EU. And the Greek Coast Guard didn't even bother to recover the body. So we are talking about concrete and imminent risks to fundamental rights. So the Lisbon, as all the lawyers in the room knows, positive obligation and negative obligations are alike, are compulsory on the agencies, and the positive obligation, the best manifestation of this positive obligation under the Charter is in Article 46, maybe the only article almost in the Frontex regulation. And over there, it's quite simple, but people get it sometimes wrong, including, I heard a lot, the new fundamental rights officer, his reading of the situation, which I find completely legally flawed. Well, the point is that if we agree that there are systematic or serious human rights violation, then the executive director shall, we are all lawyers, we know that in our legal language, shall means must, otherwise the legislator would have said may. So he must take one of six measures enlisted in this only one single article that regulates human rights violations in the Frontex regulation. So it's not about whether if the executive director take the measure, but what measure he must take, okay? And now to get to my point in today is that after outlining the structure of the argument, which is the TFEU failure to act in infringement of the treaties of the Charter of Lisbon, positive obligation, which are vested in Article 46, and the obligation, no discretion is left for the executive director to react. I didn't say what to do, maybe to finance partially something, to suspend for a day, one region, one boat, and to react is the obligation with no discretion. the main point, I will make now 3-4 points in the time that I'm left with, which is around 5 minutes. The main point that most jurists miss is that Article 46 doesn't require Frontex agents to commit human rights violation. Rather, the legislator thought that the EU symbol, the EU forces, EU coercive law enforcement agency, if they are in a neighborhood where fishy stuff are taking place, human rights violations systematically are breached, they should take off, or they should be suspended, or they should withdraw the financing. This is, no one said it can be Al-Qaeda, it can be the Hellenic Coast Guard, no one said who is the one that is violating human rights. It doesn't necessarily have to be Frontex, it's only related to the activities of Frontex, joint operation with a body, with an entity that breaches human rights, that is the Greek Coast Guard, is enough to activate Article 46. This is one point. Then I hear from the new fundamental rights officer, echoing the executive director, saying that the presence of Frontex forces on the ground has a chilling effect, which is of course factually false, because we had a lot of time to see what chilling effect has Frontex on the Greek forces. But also legally, what I'm really stunned to see is that a lawyer saying that he wants to use Article 46 as a leverage to have an impact, and it's a chilling effect. First, if there is a chilling effect, it means that there are human rights violations taking place. Otherwise, what there is there to chill? And secondly, and more importantly, it's not about the fundamental rights officer or the executive director to decide whether to suspend or terminate an operation. It's not up to their discretion. The legislator thought that once there are human rights violations, Frontex must take off, not be there. EU forces must not be there. It's not about it's not a test of result. Even if they were chilling the Greek forces, it's about a test of conduct. So there is no, maybe they are chilling, maybe they are hitting, but the law is simple. It says if there are human rights violations, you do X, Y, Z. It's not up to the fundamental rights officer to decide how he uses his mandate. It's an obligation. Secondly, and this is also another example for how the structural and the cultural corruption of this organization, as the commissioner said, it's not about Legere, we are used to it. He's lying to the parliament, he's lying to the commission and so on. But this is when we say, when the commissioner said the old culture, culture is more than one person. It's all the employees, all the agents, senior officials, including the fundamental rights officer that are operating. And we can see it in his position on the monitors. He said the monitors, yeah, the law says it's, I have to have 40 by last December, but I have 20, and actually I prefer to take it slowly, and in 1 year, in 2 years, in 3 years, to a stagnated approach, he called it, because for him it's easier to adjust. This is the law. I don't like the red traffic light outside my house where I'm waiting with my car 10 minutes, and I'm not saying, okay, in 2 years I will pass in a green and I will wait. This is the law. This is not a migration crisis. This is not a human rights crisis. This is a rule of law crisis. The fundamental rights officer must understand that monitors, 40 monitors is in the law, and it must have them yesterday. And to monitor and not to call, in order to acknowledge human rights violation, you must monitor them, then you must report them. Then he says the SIR are tools of reflection, the serious incident report, and you must react to them. And now we saw what happened with the previous fundamental rights officer, the one that said we must take off of Hungary, that Frontex must withdraw from Hungary, no one listened to her. The one that said Frontex must take off from Evros, no one listened to her. And until she was completely dismantled. And now we brought a new one saying, you know, I want to use my mandate to create safeguards, to improve the situation, to use it leverage on the member state. The leverage is to comply with EU law and to reinstate the rule of law in the EU external borders. And Front-Lex, together with the Greek Helsinki Monitor and the Progressive Lawyers Network law firm from Brussels, will make sure that the Court of Justice of the European Union will conduct oversight over the organizationally and culturally corrupted conduct of this agency. Thank you very much.
Thank you so much, Omer, for your, I would say, passionate talk and for, introducing into the whole discussion the rule of law element, which is very important. And our last speaker, before we start the discussion, will be actually the only speaker we have with us in the room, for which I'm really grateful. So it's Professor Achilles Cordas, the Senior Research Fellow at Max Planck Institute for Comparative Public Law and International Law in Heidelberg. And he will talk about the return of geopolitics and the transformation of migration law. So Achilles, please, the floor is yours.
Thank you, Madam President. I know that it's a time now that everybody is looking for the coffee. So I will try to comply to your expectations by being as brief as possible. My job is a bit difficult because I have to put different arguments on basic assumptions that we have had during that conference. But let me make an effort from the standpoint of an international lawyer. The international community is composed of states. Let me begin with the fundamental. States and spaces, that is, regions with specific interest. States have borders, spaces have frontiers, and they make a policy, legal policy, or policy with regard to security. There is a difficulty for an international lawyer to accept that wherever you are in the world, if you come up into a border and you say, I want asylum, the doors will open. This simply doesn't work in the international community. It may work in Europe. I don't dispute that. But let's try to go to some of the other 192 states in the world, with the exception of the 27 or the 40, I don't know how, 47 of the Council of Europe. I doubt that all of them, by the way, would open their doors. And this is not a sort of bad faith, but there is a conflict at the heart of international law and at the heart of the international relations. We have heard it many times, but now it takes a different quality. The conflict between what we call human rights and sovereignty is a cheap formula, but it hides a reality which is always present in the practice of the international community. And somehow what it changes is the content. Niklas Luhmann had said 30 years ago that the changes in society, the structural change is quicker than the change in the semantics. What happens is quick, but we need time to observe it and realize what is going on. And what is going on now, it's very important. We enter a new geopolitical era where the conflict is between regions. It's long-term, it will last. The way it happens may protect us from war, but it will not protect us from continuous tensions and conflicts. They will increase rather than diminish. I will just bring the example of the Greek-Turkish border crisis a year ago. It was significant that it was the first time that something like that happened in international law, apart from older stories between India and Pakistan, but this is another issue. But it is, in modern times, the first time that migration was instrumentalized for reasons of geopolitical antagonism. I don't want to say that Turkey didn't have its reasons. It had its reasons. There are many reasons, but this is not my topic. And some of them were justified. But then it was followed by Morocco and Spain, and then it was followed by Belarus. And let's not forget the geopolitics of the terrorist groups that want to infiltrate mass movements. We remember the 2015 attacks in Paris still. So there are geopolitical risks. There are no enemies, but there are risks, and these risks need to be managed. There is a permanent practice of the United Nations Security Council, which is the organ that has the authority to decide with binding force, the only organ in the international community. Since 1991, it has characterized the mass movement of migrants or refugees as a result of an armed conflict as a threat to the peace. So the mass movement itself, this happened in Iraq, 91, it happened in Yugoslavia, Kosovo, and Bosnia, it happened in Haiti. And last but not least, the resolution 2240 of 2015 characterized the movement of migrants from Africa to Europe via Libya as a threat to international and regional peace and security. So the consequence is that smuggling must be fought against. So I don't agree with the very somehow the feeling that smuggling is a matter of punishing the smuggler but not the refugee. Smuggling is destroying the activity, business activity, mafia activity of millions and millions of dollars every year. The UN reports on the African crisis say very clearly that the money of smugglers partly are used to finance terrorism in Africa. So it's a serious issue that we should consider. According to a study of the European Parliament, 90% of migrants coming to Europe, they come through smuggling activities. But let me go quickly to the pushback. And there are many pushbacks. Some of them are legal, some of them are illegal. I don't have the time to go into the details. But here is a fundamental conflict at the heart of the European Union law this time, which is between the obligation of Frontex to protect the external borders, and these are legal acts taken according to the primary and secondary EU law, and the rights of refugees and the need to protect them. And this collision cannot be resolved simply by saying one of the two prevails always, because then, again, if everybody coming from Turkey to Greece saying, I'm a refugee, he has the right to go to Greece, then it means that Frontex is not necessary. It may be, but this is a political decision. It's not up to us to decide to abolish the Frontex, whatever are the good reasons that may exist. This normative collision appears in the first place in Article 21, paragraph 2 of the Treaty on the European Union, which says that the Union's role is, among others, to safeguard the fundamental interests, security, independence, and integrity of the Union. So what happens, and this is the problem now of suspension, for instance, of asylum procedures. After the Greek-Turkish border issue, I have written 2 blogs where my position was that it may happen through Articles 72 and 347 of the Treaty on the Functioning of the European Union. Temporary suspension of asylum is possible. There are the national security clauses and public order clauses. They are there. There are nuclear options. We shouldn't go too quickly to them, but at the last, if nothing else can happen, if there is a crisis of that dimension, then this is a possibility. Let's not forget, in Germany, the Alternative für Deutschland was 4% before 2015. Within months, it reached 17%. This is an internal destabilization of the biggest country of the Union. That was a good management by the German political elite that has managed the problem. Now, let me come to the European Court of Human Rights. There are 4 decisions on interim measures with regard to Belarus, with Poland, Lithuania, and Latvia. Taken together, these interim measures say that refugees or migrants stranded at the border, they cannot be, they create no obligation for the EU member states to admit, but they must support them through shelter, through food, through some sort of measures that are possible. In one of these cases versus Lithuania, Sadid and other, the court said that if they are already in Lithuanian territory, they cannot be deported. So they have to stay there. They have the right to stay there and continue their procedures. I will end with an important judgment of the European Court of Justice, of the International Court of Justice, I'm sorry, which has been largely ignored in the academic debate. It is the case Qatar versus United Arab Emirates. In this very important, geopolitically and legally important case, the court decided that measures of collective expulsion of Qatari citizens from the Emirates, and that was the only question that the court had to answer, do not constitute racial discrimination. Because nationality, discrimination because of nationality of citizenship, existing citizenship, is not a case of racial discrimination. With one stroke of the pen, the court decided that Recommendation 30 of the Commission on the Elimination of Racial Discrimination does not exist. And here I am. Finally, if we look at the courts of the United States, you would be surprised to hear that there was a unanimous judgment 2021, the Sanchez versus Mayorkas, which was adopted by the Supreme Court, and the judgment was written by the most liberal judge, Elena Kagan. It decided that a person with temporary protection in the United States, being there since 1999, had to be deported because he had entered illegally the United States. 20 years later, unanimous judgment. All these things show that there is a change in direction. The change is not clear. The judgments are contradictory. They're confusing, as we may see in the discussion. And this shows the moment of change that has not been yet completed. Thank you very much, and apologize for going beyond my time.
Thank you so much, Achilles. Thank you for approaching this topic, I would say, from a little bit of a different angle or a different perspective, which some of the people in the audience here might not agree with, but I think that's why discussions are useful. And thank you for, I would say, entering another element into the whole discussion, the element of national security. So now we have something in between 15 and 20 minutes for discussion. So shall we then first ask Marco whether we have somebody online?
Yes, thanks, Professor Lang. Yeah, we have one question online posed by Stephanie Pope. And the question is for Mr. Grimheden. And the question is to what extent, and if so, how in practice, will you and the other FROs engage or cooperate with NGOs in carrying out your mandate, including in terms of reporting incidents, receiving relevant data and evidences, and particularly considering that individuals affected by fundamental rights-related incidents or violation may often not be in the position to report incident themselves. Thank you.
Let's collect a whole set of questions. So we have a gentleman over there. Then I think the next one was Daniel. So please go ahead.
Thank you. My name is Vít Novotny. I'd like to ask Mr. Grimheden as well a particular question about Hungary. You mentioned a mission or you traveling to Hungary, perhaps. I just want to ask if you would clarify. Frontex had to withdraw from Hungary because of non-compliance with a court judgment. What is the cooperation between Frontex and Hungary at the moment? Thank you.
Thanks. I have two questions. The first one is a follow-up to the question asked by the person online. I would ask it in a more general manner, also to Mr. Grimheden. You mentioned the little numbers of individual complaints. As far as you are concerned, what are the reasons for the number? Is it a lack of knowledge? People do not know about this option. Is it maybe a lack of interest or even a lack of trust? People do not trust you yet, which could be an option. Is it factual hurdles, like the one mentioned by the online question? Or is it also legal issues, like questions of jurisdiction, since your jurisdiction is not all embracing, obviously? And the second question is a question to Achilles. I mean, one of the most famous international lawyers these days is Martti Koskiniemi, and he wrote the book Between Apology and Utopia, you know that better, or in the language of international relations, between realism, that means interest-based international law, and idealism, normative international law, and he observed this constant fluctuation between the two, and you presented us more the realist perspective, which is ingrained, it's part of international law. I just wonder, what should a court like the ECJ or the ECHR do with it? Because they are not developing their jurisprudence from scratch, at least the ECHR doesn't, but he's confronted with like a line of very complex cases, and how do these cases develop, just in case you are right? Thank you.
Okay, we have more questions, so let's collect them all. I think the next one is Lillian, then was it Baldy and Sophie, right?
Thank you, Iris. I have a question for Ms. Eva Tzavala. Thank you for your insightful presentation. I wanted to ask you, to what extent are these safeguards of independence, accountability, and scope that you present as a vision for the future mechanism present in your border monitoring work in Greece and those of your colleagues as you are the president of the Asylum and Migration Working Group? If you could also comment to what extent are these a reality also for your colleagues in other EU member states, so that we better understand what is our starting point? Thank you.
Thank you, Chair. I have two short questions, one to Tamas and more a remark to Achilles. Tamas, as Iris also pointed out, you very rightly mentioned that perhaps pushbacks should be monitored. Now, let me raise you a very practical question, which the other panelists may also contribute to. What should be done? I mean, what would you consider adequate monitoring? If I have a video record, is that enough? If I have one testimony heard by an NGO, is that enough? So do you have any vision of the very concrete mechanisms, how pushbacks can be monitored? It would be very interesting to see what you would consider adequate to the follow-up, as you mentioned several times. And Achilles, of course, I respect your views, but I consider myself an international lawyer as well, and I know that many of my colleagues in the developing world would highlight that, contrary to what you say, that maybe the European states open their borders if someone claims asylum, but the others don't. In reality, most of the refugees who appeared as asylum seekers are in the developing countries, and all those international lawyers, be it Sub-Saharan Africa or Asia, they would argue that there is an obligation to let them in and investigate if indeed they were refugees. I don't think that the position of international law and those international lawyers who are faithful to international law has changed on that point.
Thank you very much, Iris. And just following on from the last statement, it is also a comment in relation to some of the views that were shared by Achilles, and I'm grateful that you did raise them, because I think it's important that we have clarity on some of these issues. I think there are legal questions to be asked, but the prohibition of non-refoulement, I would argue, is very much settled international law. The prohibition of non-refoulement is a principle of customary international law, and it is expressed in a range of key international instruments. In the European context, it's a fundamental part of the European Charter of Fundamental Rights, and it is replicated all the way down the legal framework in the EU, including down to the Schengen Border Code, Article 4 of which clearly states that the obligation on EU member states to protect borders is subject to respect for non-refoulement. So I think it is legally clear that all states have an obligation not to refoul people, not to refuse them at a border without a proper individual examination. And previous speakers have elucidated what the obligations of states are. The EU is a rules-based order. There are no legal pushbacks. Any operation that happens outside of the legal framework and outside of an individualized legal decision is an illegal pushback. I think the challenge that we all face now in terms of this conference and this moment in EU law is how do we make sure that those obligations on states are properly understood and how they are translated into practice. So any further comments on that would be good. And one final point, I had the privilege of attending some of the Frontex Management Board meetings on the inquiry that was launched into pushbacks in the Aegean. All of these issues were well fleshed out there. And on the website of Frontex, there's a management board page where you can see the views on these legal issues as expressed by the Frontex Consultative Forum, which UNHCR co-chairs, and the European Commission, all of which clearly stated that an EU member state cannot engage with people, for example, in the Aegean Sea, without doing an individual assessment, and that in reality that means admitting them to their territory, admitting them to the territory of Greece. So that's available online. Thanks.
Thank you so much. So we have a whole bunch of really interesting questions. I suggest that we start following the same order as we had with the speakers, since Jonas might need to leave early. So please go ahead.
Thank you very much. Many good questions to all of us here. So thanks a lot for that. On the ones that were addressed to me, I think I noted down 3 here. On the extent of engagement with civil society, with NGOs, in all the missions that fundamental rights monitors will undertake or have undertaken, there is an NGO component, either in preparation for the mission or during the mission. So when I have been to Spain and Greece in the first few weeks of my taking office, we also met with civil society organizations to inform ourselves, to understand the problems from their perspective, and to get a sort of 360-degree overview of views and problems. We also involve NGO reports, IGO reports, so from UNHCR and others, in the system of serious incident reports that I think you alluded to. So concerns raised in serious incident reports can also be triggered by reports like that. Secondly, in a way, the third question that I received, but that was referring to similar issues, the one on complaints. So the reasons why, and you provide, I think, good reasons yourself in the questions. It has to do with knowledge, with trust, possibly concrete factual situations, and maybe also legal. And let me try to say a little bit about these issues. I don't know from first hand, so I can only speculate, I suppose. But I think legally there cannot be anonymous, the complaints. I think that's an issue that we should try to solve somehow. How can we take on anonymous complaints and sort of protect the identity of the person who complains? They do complain to my office, and we could ensure the identity of the person, but of course, maybe persons would be only confident to submit the complaint if they know that even we would not know their identity. I think it also has to do with the nature of our activities. To have a complaint brochure, which we try to have in the locations of Frontex operations, on a desk where people come from having landed a boat for 8 days, that I witnessed in Spain. If they are interested in reading a brochure about how to file a complaint, if that feels like the right thing to do at that moment, I seriously doubt that. So I think the nature of operations is very often not the ideal context for complaints. We are working on trying to think outside of the box, how we could inform them with automatized messages somehow where they have when they have sort of time to reflect, if we talk about migrants, but also people crossing borders. Maybe it's not that easy to reach them and alert them to this. And it's of course important to stress that the complaints is about the activities of the joint operations. It's not the fact that they are being returned or anything like that. It's the quality of the return decision, I suppose, which would in most cases go to the member states. It's also, I suppose, a confusion or a complication rather between member state mandate and our mandate, where the regulation is fairly clear, but in practice that is something still that we struggle with. So many reasons in summary. And on the third question on Hungary, so indeed my predecessor, who was then, to be clear on that, the fundamental rights officer under the old regulation, the previous regulation, so less independence guarantees and a much smaller capacity in the sense of staff. She advised to withdraw from Hungary, and the executive director took that decision, but only in relation to activities that are concerned with the issue where the problem is sort of return related, or sorry, not return related, but asylum related. But there are still Hungarians being, there are still persons being returned with Frontex support from Hungary. And we're looking into that issue, but we're also looking into how could, if Frontex decides to engage in specific areas additionally in Hungary, is that advisable? Can we see some progress on the problems that were identified in relation to the withdrawal from Hungary, etc. So it's sort of a mandate that we feel that we have, that we see that we have, that we also can look at situations in countries that have been where we have withdrawn, to see if any progress has been made. Sorry for stumbling a little bit there with my words and thinking. So thanks for good questions, and I hope I could at least put some light to highlight the views of my office on this.
Thank you, Jonas. I'm just looking because I didn't see that there was another question, and if it's directed to Jonas, it is. So sorry, I'm jumping in before Eva, but I would like to give the floor to another person to ask another question to Jonas.
Emilio De Capitani, former secretary of the Civil Liberties Committee, who prepared all the regulations on Frontex. Just a question. The Ombudsman made an inquiry on the complaint mechanism of Frontex, and after this inquiry made a series of recommendations. I was just checking on your internet site. I don't see if there is any follow-up of what the Ombudsman was recommending. For instance, clarify what is meant to be a failure to act, specify which information should be contained, all these kind of things. Just want to know if there was any follow-up from your side.
Thank you very much, and nice to meet you. Of course, we take the Ombudsman's recommendations very seriously, and we have a draft rules of procedures for the complaints mechanism in the making. It's done from my side, and when that will be adopted by the management board, that will take into consideration all the recommendations that we thought we could act on. There, I think we need to still work on things like anonymity. I struggle with that word, obviously. And maybe some other details, but I think the big questions we have addressed with the revised rules. Thank you.
Thank you, Jonas. Now Eva is the next one.
Yeah. Thank you. I really enjoyed all presentations of my co-panelists, and especially Professor Skorda's. I would like honestly to have also kind of question his opinion on the EU Pact for Migration and Asylum, and whether he thinks that it's a good compromise between national security interests and human rights interests. Okay, Madam President, you made a question about overlapping or overstepping the establishment of this new monitoring mechanism, where there will be an overlap with already existing national human rights institutions' mandates. There's not one clear answer to your question. There are as many answers as member states. It is in the right direction that the text of the screening regulation leaves the discretion to the states to decide on the type of this monitoring mechanism. The specificity of its national context situation must be taken into consideration. I think also Tamas mentioned that. And that's why we at ENNHRI say that NHRI's mandates shall be consulted prior to the establishment. There is no one type of NHRIs, first of all. NHRIs can be ombuds institutions, consultative commissions, institutes. They may have an MPM mandate or not have an MPM mandate. So under certain conditions, they can be designated as this monitoring mechanism of the screening regulation. And if they're not entrusted with this mandate, they can be part of it, or at least have a clear establishment from the beginning of the principles of cooperation between existing national monitoring mechanisms and the new monitoring mechanisms. This is crucial, and I prefer the word complementarity to overlapping. Complementarity of monitoring mechanisms. And also Professor Tsurdi posed a question on what extent these safeguards that I have just proposed on behalf of ENNHRI are in reality in the field for us and NHRIs, the Greek NHRI, but also other members of ENNHRI. As I have previously said, of course, these recommendations are based on NHRI's experience. That is what we can offer to the debate, the NHRI's experience from the field. We are national monitoring bodies. We face challenges on the execution of our monitoring mandate. These challenges are compiled in this regional report that I made reference on monitoring rights at borders that will be shown out by ENNHRI. But of course, we have issues of respect of our mandate, issues of lack of cooperation from border authorities, issues of no adequate resources. Other issues, challenges from the field is with the access to documents and information. And what is also strategically, say, crucial for us is the follow-up. Once we have done monitoring, we are producing certain recommendations for reform or investigation, but there's no institutionalized, let's say, procedure for an obligation from states to follow up on our recommendations. This is a common concern among NHRIs. Thank you very much.
Thank you. And now we are moving to Tamas, and I'm really curious to hear your answer, particularly to Boldizar's practical question.
Thanks, dear Iris. Thanks, Boldi, for your question. Intriguing and stimulating as always. I mean, just some piece de réflexion, some, how to say, rudimentary thoughts and ideas. Yeah. Border monitoring, to make it work, must be able to work operationally and on the ground. And this boils down to that, the whole question of how to collect evidence on such malpractices, pushbacks, and non-refoulement. It's important that the monitoring, people doing monitoring, the monitors, must have access to all documents, all records, including electronic records like footage of electronic border surveillance tools and equipments which are used on the ground. And this also means that monitors must have unimpeded access to all places where such actions take place. be it in the mountains, be it in the woods, be it in militarized zones, such as like the border zone between Turkey and Greece, which is a military zone, and even the police can enter having the clearance from the military. Monitors must be able to enter and have the same clearance to be out there. And practically speaking, it's also a prerequisite to shadow the police officers, the border guards. I mean, to go out with the patrol teams, and of course, not just not impeding their work, but to be around and be able to see what happens in the middle of the night and in remote locations, and also to corroborate evidence. It's important to hear witnesses and alleged victims in full respect of confidentiality, of course, and also to collect information from victims and witnesses who are outside the territory, who are on the other side of the border, to corroborate again the information. And all this can feed into, how to say, well-established, well-founded findings from the ground. I mean, there's no magic formula for that, but I think these elements are actionable and can make the system operational when it comes to exploring these pushback practices out there. Thank you. And by the way, if I can abuse my speaking slot, just a question to Omer regarding the action. It's a very brave and very intellectually stimulating one from the legal perspective. One question relating to locus standi. What do you think about the requirement under Article 265, Para 3, that the individuals must be individually and or directly concerned by the failure to act of the agency? That might seem to be the Achilles heel of the whole thing, the admissibility, because of the, how to say, quite traditional or in a bit reserved jurisprudence of the court when it comes to admissibility under this kind of legal action. Thanks for that, and thanks for the question again.
Thank you, Tamas. And now, yeah, it's Omer's turn. So the question came in the right moment.
Thank you, Tamas. Yeah, I expected this question actually, because this is the question, so thank you for asking. Maybe I start from the end. Part of the answer is that, yeah, this is a case against Frontex, but just as much it's a case against the Court of Justice of the European Union, in the sense that we are challenging the jurisprudence. We expect the jurisprudence to evolve. We find it unacceptable that in 17 years of operation of this agency, again, law enforcement agency at borders, at EU endless external borders are sites of violence par excellence. There was not a single case of a human rights violation against this agency that we know very well, that violation started not today and not yesterday, but in each and every jurisdiction this organization is operating. Serious and grave and systematic and widespread breaches of international law obligations are taking place. And this is why actually we are capturing organizational responsibility on the one hand, but also individual responsibility on the other hand in international criminal law terms, because our understanding at Front-Lex is that state responsibility, with all the mechanisms my colleagues here discussed, internal and external, have failed. With this preliminary remark, and to your question, yeah, so we would argue that the applicants are the addressees of the requested measure, the requested decision to suspend or terminate the operation in the agency. We will argue that there is a direct interest and individual concern, and any other result would mean actually that there is no judicial review and effective legal remedy and oversight over the conduct of EU agencies in general, not only Frontex. So it's like it's as if let alone when we talk about jus cogens, peremptory norms, and primary obligations, and the most serious breaches that since World War II the liberal or legal order is acknowledging. So this would be one argument, but also we do think that just as someone who is in the regulation, I don't know, of anti-terror, counter-terrorism was listed in the supporting terrorism, and he has standing to challenge this measure against him or her, so does the applicants that will be subjected to measures of collective expulsion, refoulement. Their risk will be, their life will be at risk, and so on and so on. Have standing, and they can. And we knock on this door, and you're right that failure to act is very restrictive in this sense of providing natural persons, victims, standing before the court. We are trying to step a foot at the door. If we fail, the CJU, the EU law, provides just 1.5 other way, which is action for damages, which is a posteriori, which is after fact. We are more interested in the policy change and in directly challenging the unlawful measures. Yeah, this is pretty much it. But again, the court is a court of last. It's the last resort of victims of serious violation, because we see that fundamental rights officers and a complaint mechanism, and there is no monitoring on the ground as you are seeking to have in the woods, on land. There is no reporting because people are reluctant. As someone asked, why there are so few reports? There is a culture of retaliation against Frontex agents that seek to report on serious incidents. But when the fundamental rights officers terms a serious incident report as tool for reflection, when monitors are just a recommendation, not the EU law in its regulation, when investigation of the serious breaches, people, the moderator said I'm passionate. I find all of us not passionate enough. Maybe it's the career of representing hundreds of asylum seekers in different jurisdictions, but people are not in Brussels. People are on boats in the central and the eastern and the western Mediterranean, and there is not a single individual assessment of their situation. Okay, so the respectful professor said there are legal pushbacks, there are no legal pushbacks. In the end of the day, it comes down to one issue: are you conducting an individual assessment or not? And the Greek says we do. From 10,000 asylum seekers in the Aegean Sea, we did one after another individual assessment, but not a single person expressed or manifested asylum. This is the Greek version, okay? And the Frontex version is, there are violations, there are not violations, there is individual assessment, there is not, so we will legalize the collective expulsion under 656 2004. All this like invention of the law and trying to, we have enough law, we just need to comply with it, and we have enough mechanism, and we just need to respect it, that's all. So we expect the court, because really it's the last station of victims of serious and grave breaches of, because also you can look not only on the monitoring, but on the political level, the member states, they are sitting in the management board, they can activate 46(2), which will call the executive director to suspend or terminate, right? They are, the commission, they have 2 seats in the management board, right? The parliament, powerless. So this is the investigation of the internal Frontex doesn't even worth to address. There were no lawyers there. Why won't the respectful fundamental rights officer will ask why the Frontex scrutiny group, the internal one, the members of this commission have no
I'm sorry.
lawyer.
I'm sorry, Mr. Shatz. I'm really sorry to interrupt you, but we are really running late, and so if you can just really wrap up, because we still have Achilles waiting for his responses, and we have another closing session, and people will have to go to the airport. So sorry to interrupt you, but if you can just wrap up.
No need to wrap up. I think the idea is clear. If you have an investigation committee where all its members, there is not among all its members, there is not a single lawyer that investigating the most serious violation of human rights law, something went wrong in this organization. And I was disappointed to see that the new appointments are pursuing the same line of that's it. Thank you very much, and sorry for taking so much time.
Thank you. And last but not the least, Achilles, please go ahead.
Thank you, Iris, very much. I would first like to thank you for tolerating my positions without kicking me out of the room. I find the questions extremely interesting, and I would like to respond to them. Daniel asked about apology and utopia. Indeed, Koskiniemi, at the end of the 80s, had developed this idea between apology and utopia. He meant that international law is not really concrete, it's very fluid, and depending on the interest, we go the other direction. Well, that was when the Americans had made their arguments during the Cold War on the right to democracy, on intervention in Panama. It was before that, I think. But anyway, the idea of democratic interventions, so he used the example to say, well, there's no international law, but we are moving right and left depending on the circumstances. Well, then the Cold War ended, and then the Americans were really powerful enough to say, well, that's the new international law. Then he changed his mind, and in the fragmentation report to the ILC, he said, oh, formalism is the religion of the future. So he turned around his argument. So these are intellectually productive ideas. I take a more sociological approach, that is, ideas and interests, they build on each other. In every moment in international law, we have alternatives. But these alternatives build upon what already exists. There is a huge building of international relations of centuries. You cannot tear it down and rebuild it in one day. So it's a big thing behind, and as we have seen in the 21st century, the idea that the state is disappearing was wrong. I was one of those who believed, okay, now we are in the brave new world of global society. It's not as simple as that. Now, how the courts can react, that's an important point. Well, the courts, if we look also at the International Court of Justice, they have many ways of evading questions. They can, we have the policy of judicial avoidance. If there is a complicated issue in a topic which is under evolution, the court finds a way procedurally or otherwise to go away. Or it gives an answer which is contradictory. The example is the European Court of Human Rights in this Belarus cases. The answer is, gives a solution for the moment, but if we look deeper in it, it's contradictory. It doesn't make fully sense. And sometimes the courts may show their displeasure at the possibility of abusing rights. There is one case by the Court of Justice of the European Union. It was a complaint on behalf of Afghan refugees in Lesbos. One of them has said, well, I want to go to Belgium because I met some nice people, Belgian soldiers in Afghanistan. I mean, that was in the judgment itself. So the claims were rejected by the General Court, and then the Court of Justice said that, well, enough is enough with such kinds of complaints. So it was a very aggressive way to show its displeasure. So the courts react in a way that it's not consistent, and it brings into the appearance these dilemmas of the moment of variation and selection of norms. So it's a moment of confusion until a new law is stabilized. I cannot tell you what's the new law because it doesn't exist, and evolution is not a matter of planning, it's a matter of life. So we will see where these things will go. But let me go to Boldizer, who, as an international lawyer, is absolutely legitimate to make the critical question. Well, refugees in developing countries, don't they go through the borders? The Organization of African Unity, doesn't it permit and accept the protection in cases of mass exodus? You seem to have right. But let me question you. The Organization of African States, the Refugee Convention, says, with one exception, we don't accept those who are involved in subversive activities. You know, that's the heart of being a refugee. You are in subversive activities. So you are not protected in Africa. It's not the non-refoulement that we know. And then we should distinguish between admitting massively refugees and refugees moving from one country to another because of lack of any border controls. As the case is in Africa, it's practically impossible to control the borders. And when this mass movement happens, well, we have Rwanda and Congo. 1 million Rwandans have fled to the Congo. They have remained there since the war in Rwanda, 20 years war, 5 African countries involved, 4 million of victims, hundreds of thousands of raped women. The destabilization brought by that movement from Rwanda to Eastern Congo destroyed the state of Congo for 2 decades. And still, there is no peace in the region. And I wonder whether the moment comes that extremist groups will be active there, as we never expected to happen in Mozambique, for instance. And let's take a look how many states have ratified. Yeah, I try because, I mean, I know that the colleagues have made interesting points, but I concentrate now on Sophie because she said important things. Well, not every pushback is illegal. It's pushback and pushback. I mean, a yacht bringing Turkish refugees over the Aegean, they are refugees because they are opponents of the regime. But Syrians who are covered by the EU-Turkey statement, well, if they have not entered the Greek zone, why should they be permitted to go there? The Turkish Coast Guard, that's the practice, is communicated upon and they take them back. We should not go into the idea of totem and taboo. It's a totem to say non-refoulement, it's a taboo to say pushback, but things are much more complex. And I end that by saying if the UNHCR or our colleagues are so convinced that non-refoulement is at the top of the hierarchy of international law, let's ask an advisory opinion by the International Court of Justice, which will bring the borders and the distinctions between refugee law, law of the sea, human rights, international humanitarian law, and let's see which are the borders. Mind you, under the law of the sea, there is no right to enter a port. There is an obligation to rescue, but there is no right to enter the port. So things are extremely complex, and we should go case by case. That's my only answer for now. Case by case responses. About EU and new pact, Eva, I do not know. I'm not insider in the Commission. Thank you for your patience.
Thank you so much. So this brings us to the end of a very interesting session. I would like to ask you to join me in thanking both the speakers and the excellent questions that we gathered from the audience. So thank you once again. And now we have the closing session, and I'm looking at Philippe. Should we go straight away to the